Hi, everybody, it's Tom Woods, and today we're going to talk about the idea of the Constitution as a living, breathing document. If you've never heard this phrase, well, you'll understand what it means at the end of this lesson. But let's review what we covered last time. This whole week we're talking about the general system of American constitutionalism, of American government, and the role of the Constitution in American government, how it was originally intended, and then what actually became of it, what became of the Constitution, what became of the American system. So last time we noted that the American system was one that envisioned a government in Washington, well, eventually it winds up in Washington, that would have limited powers. It would be, these are called enumerated powers. They are the powers that are expressly listed in the Constitution in Article 1, Section 8. Those would be the powers of the central government. Anything not listed in that section, and anything that isn't actually prohibited to the states in Article 1, Section 10, where the states voluntarily agree not to exercise certain powers, anything that's left rests with the states. And so this is how the Constitution was interpreted. If there's some proposed government power that's not listed in the Constitution, then the federal government does not have that power. That power remains with the states. If it's with anyone at all, it would be with the states. And the states can choose whether or not to exercise that power. So that was the argument that we looked at last time. And we also, last time, looked at the importance of self-government in American history. In the American Revolution, as the whole point of the American Revolution, the American colonies wanted self-government because they were tired of the British telling them what to do. Well, likewise, the American states want self-government because they don't want their central government telling them what to do. So it's exactly the same principle. And so they insisted, many of the American states, that the Constitution have added to it an amendment that would guarantee the self-governing rights of the states. They would say that the central government can deal with foreign policy and things like that, but anything having to do with the internal affairs of our states, these are decisions for us to make, and it's not for them to interfere. And so we saw that that principle was enshrined expressly in the Constitution in the form of the 10th Amendment, which in effect says that all powers that the states have not delegated to the federal government remain with the states. We talked about some of the advantages of a system like this, a federal system, where power is divided. You have a central authority, and then you have the states, and they, in effect, share power. The federal government does some things, states do other things. Talked about that. But now today we're going to talk about what happened later. Because it's true that initially there was this understanding that the federal government had only limited powers, Article 1, Section 8. And it couldn't interfere with anything else. It couldn't exercise any other power other than the ones given to it in the Constitution, in Article 1, Section 8. And if the federal government did exercise some extra power that wasn't listed in there, then it's violating the 10th Amendment to the Constitution. And the 10th Amendment was initially taken very seriously. But as time went on, especially once we get into the 20th century, it became much, much more fashionable among legal scholars, so-called, and politicians to try to claim that, you know, you people are just too... You're too hung up on the text of the Constitution. You know, you got to get with the times, man. The Constitution has to change with the times. The Constitution it can't be a dead document from 200 years ago. It's got to be living and breathing and changing as we change. You know, you got to get hip. That became the new way of thinking. Don't get so hung up on the text of the Constitution. If we really want to do something, then, you know what, let's interpret the Constitution in such a way that it allows us to do it. So in other words, this increasingly fashionable argument is that the Constitution has got to change with the times. Now what that really means, although they never quite put it this way, for reasons I'm sure you can appreciate, they never quite put it this way, but what that really means is that judges should interpret the Constitution according to how they think it ought to be read today. So really what you're saying is judges ought to have plenary power to interpret the Constitution in such a way as to allow the federal government to do all kinds of things. So in other words, we have to rely on the judge. The judges will decide what's best. They'll know how the Constitution needs to be interpreted in the year 1950 or 2000 or 2014 or whatever. They'll know exactly how to interpret it for us today. Now, that may, in fact, give the Supreme Court an enormous amount of power when you think about it. They get to interpret it not according to the words or the original understanding, but according to the changing values of the public. Well, that could be fraught with peril and danger. So that's the argument, back and forth, is that you have some people who say you have to interpret the Constitution the way it's written and the way the people who drafted it intended it to be interpreted, and then other people who say that's just fuddy-duddy stuff. That's back from the old days of horses and buggies. That's what President Franklin Roosevelt said. That's from the old horse and buggy days. We got to interpret the Constitution really broadly in such a way as to allow the federal government to do all kinds of things that some of us might want it to do. Now, it's here that it makes sense to point out that the Constitution has within it a provision that allows for a case like this, where maybe the people have changed, their views have changed, society has changed to some degree, and so maybe some aspect of the Constitution is out of date or not applicable, etc. So this was already anticipated by the people who drafted the Constitution. They inserted the amendment process. There are two different ways in the Constitution whereby an amendment can be added to the Constitution. A change to the Constitution can be made. And one of those ways, the way that's actually been used every single time, is that Congress simply introduces an amendment and it's voted on by the states. So if you're saying the Constitution needs to change with the times, it can change with the times as long as you amend the Constitution to reflect that change. Now, how do we know, by the way, exactly what the Constitution was intended to mean? Because I've been saying a lot so far in this lesson about interpreting the Constitution the way it was originally intended. And whereas we have other people who say, no, we got to interpret it in a way that conforms to our current values and views in the current day. Well, how do we know what it was originally intended to mean? And I remember being in grad school, and the consensus among the students was, well, nobody can ever know. Nobody can ever know what it was originally intended to mean. And of course, they loved thinking that. Nobody could possibly know what the Constitution was originally intended to mean, and what followed from that, of course, was, so therefore, let's just do whatever we want. But you can understand what the Constitution was intended to mean, at least in most things. And to find out what it was intended to mean, Jefferson and Madison urge us to look at the proceedings of the state ratifying conventions. That's where the people discussed the Constitution. That's where the people were told what it meant. That's where they were told, this is what's going to be binding on you if you agree to this Constitution. That's where you look. So it's not like there's no way to figure it out. You look at the ratifying conventions. Now, Jefferson has a very, very important statement I want to make sure you understand, because it relates very closely to our topic for today. Should we interpret the Constitution according to its original intent, or should we let the judges decide how today it ought to be interpreted in line with our changing values? Jefferson said, I had rather ask an enlargement of power from the nation, where it is found necessary, than to assume it by a construction which would make our powers boundless. Our peculiar security is in the possession of a written Constitution. Let us not make it a blank paper by construction. Now, I hope you understood what that meant, but if not, we'll go through it. First of all, construction, he means not in the sense, of course, of building something. Construction, he means like construal. That's the kind of construction he's talking about. Interpretation is what he means by construction. So he's saying, in other words, let's say that we want the federal government to do something, and we look at Article 1, Section 8, and that something is not listed in there. Well, Jefferson is saying, well, how should we handle that situation? We want the federal government to do this thing, but it's not listed in the Constitution, so how should we handle that? And Jefferson says, well, I would rather ask for an enlargement of power. I'd rather ask of the nation. I'd rather ask the nation, ask the people to grant the government this enlargement of power, to say, okay, we agree with you. We want the federal government to have this extra power. So Jefferson is saying here, I would rather get the people's approval for an amendment to the Constitution. If we really need to change it, if we really want the federal government to exercise an additional power, then I would like to go to the country and say, we need this extra power, so please ratify an amendment to the Constitution that would give us this extra power. He said, what I do not want to do is just say, well, we really wish the federal government had this power, and it's not listed in there, so let's just interpret the Constitution so broadly that it includes this power. No, because Jefferson says, no. If we need this extra power, ask for it. Get an amendment. Change the Constitution to authorize it. But don't just start exercising the power by interpreting the Constitution so broadly that now suddenly you're allowed to do it. By interpreting the Constitution in such a way that this power is suddenly magically included. He says, because that would make our powers unlimited. That would make the federal government's powers unlimited. If we, in effect, get to the point where we say, we want the federal government to do this, this thing is not listed in the Constitution, it would be too much of a pain in the neck to go to the trouble of amending the Constitution, so let's just go ahead and do it anyway. Let's have the federal government exercise that power anyway. Jefferson says, then you may as well not even have a Constitution. What was the point? What was the point? What makes us secure in our liberties is that we have a written Constitution that spells out what the federal government can do. If we interpret that Constitution in a changing way, and we interpret it in any way other than according to the words that are in it, if we just say, well, hey, let's not be fuddy-duddies here. We need the federal government to do a lot of extra things, so, well, let's just read it in a very, very broad way to let the federal government do what it wants. Then Jefferson says, then you know what you've done? You've given yourself, instead of a Constitution, you've given yourself a blank piece of paper. You've given yourself a blank piece of paper, something that can't possibly ever limit government. If you're going to always have some excuse or some bizarre or very strained constitutional interpretation allowing for everything you want the federal government to do, then what was the point of having a written Constitution in the first place? Now, there's a Yale scholar named Bruce Ackerman from the 20th century who argued that over the course of American history we've had several what he calls constitutional moments. For example, during the Great Depression. That was a time when, according to Ackerman, every reasonable person, he says, in American society agreed the federal government needs more powers to cope with the Depression. And so we're not going to bother going through the trouble of amending the Constitution to give it all these additional powers. We just know together, as a society, the federal government needs to be stronger and it needs more power. So this is a constitutional moment, and from now on we interpret the Constitution differently, even though we haven't gone through the formal process of amending it. That's what Ackerman was driving at. Now, later in this course, when we get into our unit on the lessons of history, I'm going to take 2 lessons to talk to you about the government's policies during the Great Depression, and we'll see if those actually were wise policies or not, or if it was a good thing for the federal government to exercise these additional powers. But this is a very common sort of way of thinking among the people who believe the Constitution should be a living, breathing document. That's what they say. That you old fuddy-duddies think it should be this dusty old document that never changes, but we think we got to change with the times. It's going to live and breathe and change with the times. Now, again, if you wanted to change with the times, just go ahead and amend it. It's not a problem. But it's interesting to note that Alexander Hamilton, who was one of the people who wrote The Federalist, or it's known today as the Federalist Papers. Let me pause and just tell you what this is, because you may not have had this in American history yet, but when the Constitution was being discussed, especially around the time that New York was considering the Constitution, Alexander Hamilton, James Madison, and John Jay together wrote a series of 85 newspaper articles that were later collected into a single book, that you can get this book anywhere, called The Federalist. And these were articles in which these men, writing under a pseudonym, argued in favor of the Constitution. And so we title each one of these articles just by the number, the order in which it came out. So one of the later entries in the Federalist series was Federalist number 78. And in Federalist number 78, Alexander Hamilton, who was a very influential figure, who favored a more centralized government than most other people did, but Hamilton said in Federalist number 78, as if anticipating Bruce Ackerman, He said, until the people have, by some solemn and authoritative act, annulled or changed the established form, it is binding, and no presumption or even knowledge of their sentiments can warrant their representatives in a departure from it prior to such an act. I mean, that's almost breathtaking how precisely he anticipates the argument of Ackerman. So again, if this language is too difficult for you, let's go through it. He says, until the people have, by some solemn and authoritative act. So basically what he means is, until the people have actually amended the Constitution to prove that they have changed their minds, that they want the federal government either to have an additional power or to have one of its powers withdrawn, until they've actually formally done that, the existing interpretation is binding on them. The existing text of the Constitution is binding. And even if we know how they feel, even if we know that everybody in society thinks the government needs more power, he says no presumption or even knowledge of their sentiments, even if we know how they feel, nothing like that can justify their representatives in departing from the existing interpretation, in departing from the existing Constitution. Their representatives in Congress are bound to act according to the Constitution as written. They will not have the excuse of saying, but I know that the people now are more broad-minded and they want us to have more power, so we're just going to go ahead and exercise those powers. No. Not until the people, by some solemn and authoritative act, have changed the Constitution can you do that. What's very interesting in this whole discussion of a living, breathing Constitution is that the whole American Revolution was fought against a living, breathing Constitution. So you could argue that the idea of a living, breathing Constitution is spitting in the face of the patriots who died for American independence. Because remember, the British did not have a written Constitution. The United States is the first country in the world to have a written Constitution that is still in existence today. The British had an unwritten Constitution. That meant that the British Constitution was a collection of documents, was customary practice, was the traditional way of doing things, was long-standing liberties. So the colonists' view, and this was the standard view for a long time, was that the British government was behaving unconstitutionally, not if it violated Article 7 of the Constitution. There was no Article 7 of the Constitution. There was no written Constitution. The colonists said that the British government violates the Constitution when it departs from the usual way of doing things. Tradition was the Constitution. So if the British start banging down our doors with very vague and general search warrants, and they've never done this to us before, that's unconstitutional. That's a departure from tradition. That's a departure from customary practice. That's a violation of a traditional right that Englishmen have long enjoyed. That's unconstitutional. But the British response was, look, if Parliament, the British legislature, if Parliament says that some action that it takes is constitutional, then it is. It's constitutional if Parliament says it is. So you see the conflict between the colonists and the British. The colonists are saying, wait, we have a standard by which we can judge if you're violating the Constitution or abiding by the Constitution, and that is tradition. Are you doing things the way they've always been done, or are you departing from the way things have always been done? Because if you're departing, then you're violating the Constitution. But if you're in line with tradition, then you're in line with the Constitution. The British government view was, well, as long as Parliament says it's okay, as long as if Parliament passes the law and goes through the process of passing the law, duly passes it, that makes it constitutional. It's constitutional because we say it is. We don't care about tradition. If we say it's constitutional, that makes it constitutional. That's a living, breathing Constitution. Because you have no idea from one day to the next what's going to be constitutional. You could say to the British government, wait a minute. How can you do this all of a sudden? This is a break with tradition. This is unconstitutional. The British could say, well, we say it isn't. That's a living, breathing Constitution. That's why Americans were so fearful of a living, breathing Constitution, because they lived under one. That was what the British Constitution was. The colonists wanted a fixed Constitution so they could nail down what the British government's powers were, and they could use that Constitution to protect their liberties. But the British Constitution was so flexible that you didn't know what it was going to be from one day to the next. How can something like that protect your liberties? So the irony of all this is, according to my friend and co-author, Professor Kevin Gutzman, he and I wrote a book together called Who Killed the Constitution? And he says, actually, this whole living, breathing Constitution is actually a dead Constitution. The idea of a Constitution that can just change with the times and we don't really know what it means until the judges tell us what it means today, that's dead. It's dead because how can it protect your liberties? Because tomorrow it'll say you don't have those liberties. Because, hey, you're living in the past, man. You're interpreting it the way we used to interpret it 2 weeks ago. But it's living and breathing, and today we say you don't have that liberty. So Gutzman says the idea of a constitution that changes with the times, that's not living and breathing. That's a constitution that's dead. Dead and unable to protect your liberties. Dead. That's what really is going on when the Constitution is not fixed and is not interpreted according to a fixed standard, but can change with the times. You no longer have an instrument that is alive enough to defend your liberties. All right, that's it for today. Thanks for watching.